Hi there. This is Skip Reynolds with Skipton Law, Estate Planning and Elder Law here in Centennial, Colorado. And what I want to talk to you briefly about today is powers of attorney. See, one of the things that we find in our office is that people know that they need a power of attorney, whether it be a financial power of attorney or a medical power of attorney. They know that they need this power of attorney. But they will go out and they will get this power of attorney from one of lots of different sources, whether it be online resources, a store down the road that sells them. Maybe they even went to an attorney that does estate planning or maybe doesn't do estate planning. And they've got what they think they need. The problem is, and what we find in our office, is that just having the document may or may not be enough. Because if you have a document that is either not the right state, so maybe it's not Colorado specific or wherever you might live, but it also might not have all the powers that you want in it. So one of the things that I've found personally and professionally is that if we don't understand something, especially as it pertains to our finances, so the financial power of attorney, or what some people call the general power of attorney, if you don't understand something, you are less likely to give any power regarding that, especially as it deals with our money, because we don't want to have somebody steal our money or take our money or whatever. And so what we found is many people have come in, they have a power of attorney that might be the Colorado statutory power of attorney, but there's a whole section on that power of attorney that has line items. And you have to decide whether you want to grant these powers or not. And if you do not initial them, you have thereby not granted those powers. And so you have a power of attorney, it's signed, it's valid, it's ready to go, your family knows that they have this power. Something happens, and now they need to start enacting that power of attorney, and they're trying to get things done, pay bills, do other things, maybe even look at something like Medicaid qualification or other things surrounding long-term care. But now you didn't grant some of these powers or any of these powers, and guess what powers they don't have? They don't have any power to do some of the things that are necessary to try to protect your estate in the event or occurrence of a long-term care event that's going to be either a short amount of time or a long window of time and can be very, very costly. All because you didn't grant the powers. But you didn't know you needed to grant those powers because maybe you did it on your own, or you did it with somebody who doesn't have experience in this area. Or maybe you got a form that's out of date. And now we don't have the power to even do something that's necessary for Medicaid without anything fancy going on. But you have a power of attorney and you think you're set. So just because you have a power of attorney, in my opinion, doesn't mean that you're all set, doesn't mean that you're all ready to go. It deserves a review, even if it's been done recently, just to ensure that you understand what it has and what it doesn't have and what you're looking for. If you'd like to learn more about powers of attorney, medical powers of attorney, wills, trusts, how to asset protect from long-term care costs and other things, I do bi-monthly workshops, educational workshops. And you can go to our website at www.skiptonlaw.com. You can find out more about those workshops, or you can call our office at 720-440-2774. We look forward to seeing you at one of those workshops, or look forward to seeing you in person. Have a great day.